Alright, so we're getting into the court case review for the AP exam. Now, these aren't all the court cases. These are the ones that I believe, if the themes stand up, these are the ones that are going to be focused on the most. And you could see these show up in different multiple choice questions, but also in an LEQ or SAQ or even a DBQ, as far as getting that information in there for the extended analysis for your SF5. Alright, so the biggest one at the start is going to be Marbury versus Madison. The question there, it deals with those midnight judges. The question was whether a writ of mandamus was the correct way to go. So the Supreme Court has to decide this issue, but in doing so, they take a look back at the Constitution and decide whether the court that this judge is supposed to be appointed to should even exist in the first place, and they rule no. And in doing so, they establish that judicial review. Alright, we're going to type that in over there. That's going to be the big thing. I'm not going to type in everything over here. You should be able to do that by rewinding this and really filling it as you go along. But the theme, the impact is judicial review, and a national government, it goes up. Alright, the power increases. Alright, and I want to copy and paste this because this is going to be for a couple of them. Alright, McCullough versus Maryland. Can a state tax the Bank of the United States? And McCullough versus Maryland, the ruling is no, because federalism. So again here, national government's power, the central government's power is going to increase. 1824, you got the Gibbons versus Ogden case. This is a steamboat case. Two different companies are supposed to have a monopoly on the Hudson River, one from New York, one from New Jersey. They conflict. It goes to Supreme Court. The decision is no. Alright. The only government that can control interstate commerce is the federal government. So again, national government power increases. And Worcester versus Georgia. Could Georgia force the Cherokee off their lands? The idea here is that we're treating natives as foreign entities within the United States, foreign nations within the United States. That's foreign policy now. Treaties with foreign nations are foreign policy. And again, federalism. Alright, John Marshall's just saying no all the time. They can't force the Cherokee from their lands, because the only one that can make or break treaties with foreign governments here is going to be the federal government. So Georgia can't do that. Now remember how the reaction goes to that case in particular with Andrew Jackson, but the court case rules that no, they could not be moved. Alright, Dred Scott versus Sanford. Could slaves be taken into northern states? The decision in this one is going to be very controversially yes. Now the controversy is now that slaves can be taken into northern states. Right? Why even have laws banning slavery? The concern here is that slavery can now expand into the north. The reason why the Supreme Court rules this way is slaves are deemed to be property, and you cannot deny somebody their property without them having committed a crime. And this is that context. Alright? Slavery expanding question mark. The civil rights cases after the Civil War. Right? The question is going to be, did the 14th Amendment protect African Americans from discriminations at the hands of private individuals? Now remember, this is after 1877, so America is quite fully into the Jim Crow era, and the question is and the answer is going to be no. So this sets up legal discrimination, which is going to be extended under Plessy. Segregation is legal if separate, or if equal. Right. Now World War I comes along. We're going to have this court case called Schenck versus the United States, and the question is going to be, can you tell people that they should not enter the draft, or is that dangerous to the country and you can be jailed because of it? So the answer to this question, the Supreme Court is going to be, alright, so the question is, could wartime speech critical of the government actions be restricted? And the answer is going to be yes, if it poses a clear and present danger. Right, and the idea here for Shing versus the United States is that telling people to burn their draft cards and not go into the draft is going to leave our soldiers at a disadvantage in fighting that war, and it's going to increase the possibility of them dying. So we can't have that. Alright, the Scopes Monkey trial, it's not a Supreme Court case, but it is going to be big as far as the showcase for evolution versus fundamentalist Christianity. The decision really isn't important. The decision was already known, but the idea here is that we're bringing these things out in a court of law and exposing them and gaining more public input and discussion. All right, Schechter Poultry versus the United States. This is dealing with codes of fair competition and whether the president should be the one to be able to issue those codes. And the Supreme Court is going to say no. That is the legislation. That is legislative, not executive. Right, and in doing so, the AAA is killed. No, NRA. NERA is killed. Alright. And U.S. versus Butler the next year is basically the same thing. There's going to be tax. What this case is basically taxes on processors of crops. They're going to be taxed. That money is then going to be used to tell farmers not to produce certain crops. Right? The question is whether those taxes were constitutional, and the answer is going to be known. And that is the major way that the AAA was working. So the AAA is killed. Alright, Korematsu versus the United States. Was wartime internment constitutional? Basically imprisoning people because they could possibly commit a crime or commit treason, not because they had possibly. The answer from the Supreme Court is yes. Internment was constitutional. Wartime restriction of rights. In 1954, was the policy of separate but equal still applicable? No. Plessy overturned. Right, so this is the beginning of the civil rights movement. Right, Escobedo versus Illinois is the question's going to be. Alright, so these are going to be the Warren Court. Going back up, where I have orange, that is going to be the Marshall Court. Marshall Court, all about those muscles, strengthening the federal government. Taney's decision, Taney Court is really, they're going to get kind of known for the Dred Scott decision. The Warren Court is all about extension of rights of the accused and civil rights movement laws. So Escobedo, when does an accused right to counsel kick in? At the arrest. Right? The idea there is, or no, not at the arrest, at the request for counsel. Alright, so before this you can talk to the police, and anything you say can be held against you. But once you ask for your lawyer, they cannot ask you any more questions. That information cannot be used against you in court. And then Miranda versus Arizona, as do defendants need to be informed that they have the right to counsel. So we've already established that they must be able to access counsel if they ask for it, but do they have to be told that they have that right? And the answer is going to be yes. You must be warned of your rights. Alright, Loving versus Virginia. Could states restrict interracial marriage? No, and this is a 14th Amendment case. Mainly all your civil rights cases are going to come back to the 14th Amendment. Basically, are we treating citizens equal? And since people cannot be denied citizenship because of their race, are they being treated equally by the government? Right, Tinker versus Des Moines. Do students have free speech rights before the age of majority? This was the Vietnam War case, right? Wearing a badge on your shirt. And the answer is going to be yes. but it is going to be qualified, if not distractive, to the educational opportunities. Alright, Swan versus Mecklenburg. Now we have Brown versus Board, and there's going to be integration in schools. Is busing the correct way to do it? The Supreme Court is going to not only say yes, it is the preferred way. Alright, so taking buses and taking students from the suburbs into the inner city and from kids from the inner city to the suburbs is the preferred way to make sure that the entire district is mixed as far as racial lines. All right, Roe versus Wade, could states ban abortions? No. All right, and this is going to be a right to privacy ruling. All right, the decision sparks a conservative political uprising during the 80s. The conservative, or the moral majority. Alright, Bakke versus UC Davis, or Regents versus Bakke case is about affirmative action. Quickly going into that case is that Bakke had applied to medical school. He had been twice turned down, mainly because of the quota system. All the white slots had already been filled, and the implication here is that there were less qualified people in medical school, but because he was white, he wasn't allowed in. So it's a reverse racism argument. The question is going to be, was affirmative action constitutional or whether it was discriminatory? And the answer is going to be yes. Affirmative action is constitutional, but quotas are not. Right? So he was let in to UC Davis, not because that affirmative action was illegal. It was because the quota system was illegal and he had been harmed by it. Alright, so Texas versus Johnson is the burning of the flag burning. Was it free speech? And if it's free speech, it has to be protected under the First Amendment. And the answer from the Supreme Court is that yes, it is political protest. Nonviolent towards individuals. So it is allowed under the U.S. Constitution, under the First Amendment. Alright, so those are the major court cases in about 13 minutes. Happy studying.